So let's just start off first with what is an estate plan and who needs one. So basically in the state of California, once you turn 18, you're deemed a legal adult, which means that if you were to lose your capacity without having a document called a durable power of attorney in place, if you were to lose your capacity, the only way that your loved ones could advocate for you is by obtaining court powers through a court process called a conservatorship, which, to be honest, Britney Spears was kind of a very bad example of a conservatorship run amok. But generally, the purpose of a conservatorship is if you are a legal adult and if you do lose your capacity, whether it's temporary in a medical situation or more permanent, like in a diminishing capacity situation, then having a durable power of attorney for financial affairs becomes very important, because when you create this document, because you have capacity when you make these decisions, the courts will give this document deference when you lose your capacity. And that is why when you have a durable power of attorney in place, your loved ones don't have to go through the courts to get court powers. What they need to get, though, is a certification from your doctor stating in writing that you lack capacity. And that's when the documents and those powers spring into effect. There's another document called a medical directive where you would name people to make your medical decisions for you if you weren't able to make your own medical decisions. So once you're 18 years of age or older, at a minimum, you want to have your 2 durable powers of attorney in place so that you can pick the people that you know and trust to make medical and financial decisions. Excuse me, should you lose your capacity and not be able to make those decisions for yourself. And then oftentimes people will ask, what's a trust? What's the difference between a will and a trust? And do I need them? So the answer to that question is, the purpose of a trust is it's basically a contract where you're putting your assets into the name of the trust, like your home and your financial assets. And the benefit of that is if you lost capacity, the people that you name as trustee could manage those assets. And then when you have a trust, when you pass away, the assets that are titled in the trust don't have to go through a court process called probate. So oftentimes people in California have a trust because they own real property, or they have over $166,250 worth of assets, because that's the magic number in California that would take your estate through a court process called probate, or they might have minor children. When you have a trust, when you pick a person called a trustee, they basically do the job of what the courts normally do in probate. So, for example, if my husband and I were to pass away, because we do have 2 minor children, one of the primary jobs of our trustee would be to manage and diversify our monies to make sure that our children have a college education if they're willing to go that direction, that they have medical insurance. And basically the trustee becomes your minor beneficiary's legal advocate. And then in the trust, you basically get to outline at what ages and what stages you're comfortable with your beneficiaries inheriting. If you didn't have a trust, and whether you had a will or not, when your estate goes through a court process called probate, once a minor child reaches the age of 18, they're legally eligible for an outright distribution of their entire inheritance. So oftentimes, just quid pro quo, one of the benefits of having a trust is when you have younger beneficiaries, because you have a trustee who's acting on their behalf, you can put contingencies in a trust that you cannot put in a will. So for example, if my husband and I died with 2 minor children, and if we had a will but not a trust, once each of our children turned 18, they would be eligible for an outright distribution of their inheritance. Whereas in the trust, we gave distributions over a period of time. So we gave a first distribution that's small at age 25 or college graduation, because statistically that first distribution is spent within a 2-year period. So it's only 5% of their inheritance. So it's not a very large amount of money. We gave a third of their inheritance when they turn 30, thinking at age 30, they're getting married, buying a house, starting a family. And then we gave the balance at age 35. So again, one nice thing about having a trust when you have minor children is you can have them inheriting those assets at a later age when they're more mature and more responsible. And then people will often ask me, what's the difference between a will and a trust, which is a really good question. So the difference is If I have a will and only a will, then there is a possibility that my estate will go through probate. So in California, if I own a house and if I have a will, when I die, because I own a house that's not titled in a trust, that asset will always trigger probate. And that's why so many people, have trusts. It's because they're homeowners. So when you create a trust, metaphorically, I like to say, think of your trust like a bucket, and you're going to put all your assets into that bucket, because when you pass away, the assets that are in the bucket don't trigger probate. But sometimes people will create a trust and they'll put their house into their trust. And then a few years later, they'll refinance their house. And unbeknownst to them, the house came out of the trust during that refi process. So it is possible that when you pass away in the state of California, that even if you have a current and up-to-date trust, if your house is not titled in the trust at the time of your death, even with a trust, you're still going to have a probate. So I do like to mention that, because oftentimes people will call and they'll say, we have a house, we have a will, and we think we're all set. And then I have the job of giving them the bad news that when you own a house, having a will isn't enough. That's when you have to think about creating a trust. And then once the trust is in place, you need to prepare a deed that transfers title of the property into the trust. And then when you pass away, you need to make sure that that house is still titled in your trust, because if the house came out of the trust at any time for any reason, even with that trust, that house will trigger that court process called probate. So when you have a will, you're basically identifying executors. Those are the people that you're entrusting to basically be your advocate when you pass away, which their job is primarily to pay your bills, close your accounts, notify your beneficiaries that you've passed, and then to make distributions to the beneficiaries that you've identified in the will. If you have minor children, then the will also is the vehicle where you're going to identify who those people are that you trust to raise your minor children. So anyone with minor children will have a will, because that's where you do the nominations for legal guardians. And anytime you create a will or a trust, and anytime you nominate somebody to be an executor, to manage assets, or to be a legal guardian to raise your minor children, you are just nominating those individuals. So only when and if the time comes does the person that you nominate first have the ability to accept the nomination, or they can decline the nomination. And that's why it's always a good idea in these documents to have at least 3 separate individuals nominated: first choice, second choice, third choice. And that's important, because if I nominated a loved one to be my first choice legal guardian, but at the time of my death, if that person now is incapacitated because I haven't updated my legal documents in a while, incapacitated individuals, for obvious reasons, aren't legally eligible to raise minor children, or to make your medical decisions, or to manage your financial assets. So if you did name somebody who was legally incapacitated, then by default, that nomination is void, and then you go to your second nomination. And let's say I nominated my sister and she agreed to be my executor, but then life happens and she's going to have to take time off for her job, and she can no longer be my executor. She could always resign that position, in which case it's a good thing to have a third person listed as well. So I do like to mention that anytime you put an estate plan together, whether you're naming people to make your medical decisions under your advanced healthcare directive, or to manage your finances under your trust, will, or durable power of attorney, or to raise your minor children, the legal guardians in your will, you are just nominating all of these individuals. So nobody's legally obligated to act unless something happens to you, and only until they formally agree in writing to assume that role. And then all of these legal documents do have flexibility of resignation built into them. So if at any time you needed to resign, you can always resign, in which case the next person listed would have the ability to step in and take over. And then oftentimes people will ask, what happens if I don't have a will or a trust in the state of California? And what happens in California, because all states have different laws, is we have something called an intestate statute. And that statute basically determines who the next proper beneficiary is to inherit your assets. So it's basically a hierarchy of blood relationships. So if I died as a married person, the intestate statute would give my community property to my spouse. But if I had separate property, those assets are divisible under the intestate statute, but depending upon how many children I have. So for example, if my first spouse sadly passed away and I'm a widow and I'm in my second marriage, and let's say I have 2 kids from my first marriage and my new spouse has 2 kids from his first marriage, and let's just say we have 2 children together for a total of 6 children. And if I died without a will or a trust, my community property would go all to my spouse. But let's say I had a house that I owned prior to my second marriage that I kept in my own separate name. When you get married in California, any assets that you owned previous to marriage that you keep in your own name is your separate property. Inherited assets that you inherit are your separate property, and any gifts that loved ones might give you is also your separate property. But separate property only stays your separate property if you keep those assets in your own individually titled account. So for example, if I was given a gift of $50,000 from my dad, and if I put that $50,000 into a joint account that my husband and I co-own together, then I've just made a gift of that separate property into community property, which means now my spouse and I co-own that money 50-50. But my point of the intestate statute was, if I'm in a second marriage, 2 kids of my own, he has 2 kids from his previous marriage and 2 children in common. If I died without a will or a trust, the intestate statute gives my half of community property to my surviving spouse. And then depending on how many children I have will determine how that separate property is divided. So if I have 1 child, then my spouse gets half of that separate property, and so spouse gets half, child gets half. But if I have more than 1 child, then the children get a third and the spouse gets a third. But when you are a blended family in the state of California, if you don't have a will or a trust acknowledging that you want your stepchildren to be included in your estate, under California intestate laws, any step relative is automatically excluded. So in that hypothetical, if I died first without a will or a trust, my assets are going to go first to my spouse. But if my spouse predeceased me and I don't have a will or a trust, then 4 of those 6 children are going to inherit assets, but not the 2 stepchildren, because in California assumes that those stepchildren have other living relatives to provide for them, which is why they're excluded. The other thing that's important to mention is that in-laws are also excluded under our laws. So if I had an estate where I gave, let's say, $25,000 to my sister, but if my sister predeceased me, but her husband was still living, he would not be the default beneficiary because spouses have no rights in estate planning under the intestate laws. So in California, if you die without a will or a trust, the intestate hierarchy is spouse first. For community property, separate property depends on how many children there are. And then you go down the bloodline to children, grandchildren, great-grandchildren. And if there are no living lineal descendants, you go back up the bloodline to mom and dad or surviving parent, but not step-parent. And then you go sideways to your siblings, which includes half-siblings, but not step. And then you go to nieces, nephews, great-nieces, great-nephews. And if there are no living lineal descendants going down the siblings bloodline, you go back up to grandparents, aunts, uncles, first cousin, second cousin, third cousin. If in the very unlikely situation we've gone through that whole hierarchy of blood relatives and we cannot find a living blood relative, then the state of California is the final beneficiary under the intestate statute, which in 21 years of practicing law, never once have I seen the state of California inherit from anybody's estate. So that's the answer to that question. If you were to die without a will or a trust, the state of California has that the intestate statute in place, which determines who the beneficiaries are. An exception to that, though, would be if I died without a will or a trust, and let's say I had an investment account, and let's say that I named my neighbor as my beneficiary, If you have a pay on death beneficiary attached to an account, and as long as they survive you, then those monies would pay directly to whoever that beneficiary is. The intestate statute wouldn't control those assets. And in a similar situation, if I had a joint account with a loved one, let's say my sister and I had a joint bank account for whatever reason, and I died first, that account would not be subject to the intestate statute because there's still a surviving joint owner who owns that account. So in California, if you have a will, the difference between having a will and not having a will is when you have a will, you're identifying who you want to be your executors and you're identifying who your beneficiaries are. When you have a trust, the benefit of the trust is now we've got a bucket that we can put our assets into so that when we pass away, there's no possibility of probate. So oftentimes people will ask me, why is probate so bad in the state of California? And the answer to that is threefold. One is it is a public process, which in our modern society of identity theft, having all of that information be part of a public process isn't desirable, because when you pass away, your date of birth, social security number, last known address, all of your assets, all of your debts, and your closest living blood relatives, all of their addresses, social security numbers, and dates of birth is all part of that public process. So anybody can go to the probate court and pull your file and have access to all of that information. The other problem with probate, aside from the fact that it's public, is it is a very slow process. And that's because under California law, the shortest time that a probate can be started and concluded is 6 months. But the reality is, if I filed a petition today to open a probate, the soonest I'm going to get that hearing is about 1.5 to 2 months from the date that I filed the petition. There's only 3 sitting judges in our San Diego probate court. They're all amazing judges, but their courts and their calendars are compacted. So because of the compacted calendar, anytime you file a pleading with the court, you're basically looking at about a 1.5 month to 2 month lag time before you actually get to the hearing date. And you need those hearing dates for the matter to proceed. So on average, most probates in our county are anywhere from 9 months to a year, sometimes as long as 1.5 years or even longer if they're being contested. And then the other problem with probate is the fees. The fees are statutory, which is a fancy way of saying that they're predetermined by law. And the way the fee is calculated is it's a percentage-based calculation based on the gross value of the assets before the probate court. And on one of those handouts that were emailed to everyone, there's some examples on there of probate fee calculations, and I would really encourage you to open that handout. It's pretty surprising how expensive these fees are. And part of why the fees are so expensive is because that statutory fee by law is allowed to be paid twice. The executor who's named under the will is entitled to a fee, plus the attorney that they hire to represent them in the probate process is entitled to the same fee. So the fee gets paid twice. And then you have around $1,500 of publication and court and filing fees that's also added to that cost. So on average, most probates that our firm has handled, the probate fees have varied anywhere from $7,500 to $25,000. We had a probate one time that the total fee would have been $175,000, which we did a fee waiver on because it was just too much money for the work that went into it. So I do like to mention that because I know sometimes, when it comes to estate planning, it is a very difficult topic for a lot of people to think about their death, their incapacity, their mortality, and to make the decisions about who you would pick to be your guardians and your trustees. And so oftentimes people make the joke of, what do I care? I'll be dead. But what they don't know is if they're talking to an attorney, in the back of the attorney's mind, they're thinking, well, okay, here's my business card, because estate planning attorneys make the most money handling probates. You make around $1,500 to $3,500 doing estate plans, but in probates, you're looking at anywhere from $7,500 to $25,000 to $50,000. And because those fees are statutory, I've done probates where I've done very little work and I've received a very large amount of compensation because the fee is calculated based on the value of the asset. So if I have a probate that just has a house that's in it, I'm not doing a whole lot of work in that probate because it's one asset. But I've done other probates where there's multiple assets, there's creditor issues, there's beneficiary issues, but the amount of assets is so small that the statutory fee is closer to $8,000, but I'm doing 4 times the work as I did for the one probate with the house that gave a lot more money for a lot less work. So I just mentioned that because I think it's important to understand that in California, if you own a house and if it's not titled in a trust at the time of your passing, probate is unavoidable. Your house will trigger probate. It's a process that can't be avoided. But there are other states like Texas, for example, where their probate system is very user-friendly, it's quick, it's easy, and it's inexpensive. But all states in the United States have different estate planning laws. So in California, because our real property is so valuable and unique, that's why California takes the position that if the house isn't titled in a trust where there's not a trustee in charge of that asset, then that asset has to go before the jurisdiction of the courts, because what the court's primarily concerned about is making sure that all the beneficiaries have been notified that you've died. They also want to make sure that the statute of limitations to contest the estate has been opened and closed. And then they want to make sure that all of the debts and taxes are paid before anybody inherits the assets. And that's pretty much what that probate process involves. Trust administration, which is the process that occurs after you pass away, is a similar process where the trustee's job is to pay all the debts, pay all the bills, and open and close the statute of limitations for beneficiaries to contest the estate. But when you're thinking about putting an estate plan in place, you're really thinking about doing 4 separate legal documents. The trust is the bucket that keeps assets out of probate. The durable power of attorney for financial affairs is the document that's used when you lack capacity, and it gives powers over assets that are titled in your individual name. So for example, your retirement assets, they legally have to be owned by you. So if you were hit by a drunk driver, the only way your loved one could access or have any control over a retirement account is by having your durable power of attorney. And if there is no durable power of attorney, they have to go through that court process called a conservatorship to obtain court powers to have their legal permission to deal with that retirement asset. So when you become incapacitated, the durable power of attorney gives powers over assets that aren't titled in the trust, but the trust has language that gives the trustee powers to manage assets titled in the trust. And then when you pass away, the durable power of attorney dies with you, and that's when the will comes into place. So the purpose of the will when you die is to basically say any asset that you have that's in your individual name that doesn't have a beneficiary attached to it, like a car, that asset through your will is going to go into the trust. It's called a pour-over will. It's a special type of a will that's used when you have a trust. But if you died, and even if you had the trust, if the house wasn't titled in the trust, the house will go through probate and the pour-over will gets introduced into the court. And that tells the judge that you have a trust. And once the judge makes the final order to change title of the house will ultimately go into the trust at the conclusion of that probate proceeding. And then you have a healthcare directive, which is a completely separate document where you name individuals to make your medical decisions when you can't make them for yourself. In the medical directive, I also ask clients to make their decisions about their burial preference, because most of us don't talk to our loved ones about whether we want to be buried or cremated or whether we've paid for these arrangements. So that is a question that I always address in a medical directive, is whether your burial preference is burial versus cremation. Have you paid for those arrangements? If you're in the military, would you like to have a military honors memorial service? I also ask about life support. If you were in a permanent vegetative state, would you want to be on life support, be taken off life support? I said in my medical directive that when that situation occurs, I'd want to be on life support for a minimum of 3 days, but no more than 15 days, just to give the family time to gather, say their goodbyes, give the doctors time to go home and get a nap and reevaluate me. But that specific provision is only going to trigger if and when the doctors have made a medical diagnosis that, in their opinion, life support is prolonging an inevitable death. So having that information in your medical directive is very healing, because sadly, when these difficult emotional situations occur, that medical directive is almost like a roadmap. So if you're comfortable making decisions about your burial preference and life support and even your organ donation preference, those are the three things that we like to include in the medical directive, because again, most of us don't talk to our loved ones about what our preferences are as far as organ donation. Do we want to donate organs and tissues? Are we donating our skin to burn victims? Do we want to be a cadaver? There's so many things now, thanks to modern technology, that they can do with our bodies, that I do think that's also an important thing to include in a medical directive. So that's typically what your estate plan is comprised of, is those 4 documents. Your 3 financial documents are the trust, will, durable power of attorney, and then the medical directive is separate. It's my recommendation when you do an estate plan, you should update the legal language in these documents about every 8 to 10 years, because the language does become stale, for lack of a better word. The laws change, albeit very slowly, but the tax laws change pretty often. 15 years ago, we used to tell clients to name their spouse first on retirement, name the trust as the secondary beneficiary. Fast forward to 2023, you don't want to name your trust now on your retirement, because naming the trust triggers an unnecessary taxable event to the beneficiaries of the trust. So for those, that's just one example of how the laws have changed over the years. For all of you who have an estate plan, or even if you don't, you should take the time. Maybe you could even do it today. Log into your UC, look at who your 403B beneficiaries are. It's prudent to have at least 2. You want a primary beneficiary, you want a secondary beneficiary. If you're able to have 3 beneficiaries, it's always better to have 3 versus 2. If you have an estate plan and if you see that you have named your trust as a beneficiary, I would encourage you to take the time and update that. If you have the trust as a beneficiary on any kind of a tax deferred asset, like a retirement asset, you are likely going to trigger an unnecessary taxable event. So that's something that you should look at. Make sure that you review your beneficiary designations periodically. If you have life insurance, you actually do want the trust as the beneficiary on your life insurance. And then for those of you who have trusts, the other thing that we always ask clients to do after they put the documents in place, we call it homework at our firm, where we give clients a checklist of things that we'd like them to do. We can be hired to help with the deed, to prepare the deed and put the house into the trust. We also prepare a document called an assignment of tangible personal property, which puts all your home, furniture, jewelry, and personal belongings into the trust. But then we give homework, because clients have to actually go into the bank and they have to retitle their financial assets, bank accounts, checking accounts, CD accounts, money market accounts, so that those assets are either titled in the trust, or if you keep an asset in your individual or joint names, you want to have the trust come on as the pay on death beneficiary of those assets. So when you put an estate plan in place, it really is a 2-step process. The first step in the process is basically making the decisions about how you want those documents to be written: trustees, beneficiaries, organ donation, burial preference. All of that goes into the planning and drafting stages of putting the documents in place. And then once the documents are signed and notarized, that's when the documents exist, and that's when you have the protections these documents afford. And that's the point in time where you do your homework. So that's when you want to go into the bank and update all of your investment accounts that are taxable, checking, savings, things like that. Life insurance, I've got my trust as the primary beneficiary. My husband's listed second. The kids are listed third. So you can have multiple beneficiaries, but the trust is always the preferred beneficiary on the life insurance. And then the deed, if any of you have a trust, I would check your property tax statement. If the house is in trust, on that property tax bill, there should be some type of an abbreviation as to the name of the trust. So sometimes, again, when people refinance, the house comes out of the trust unbeknownst to them. You got to make sure that the house goes back into the trust. If you have timeshares are treated like real property, but most timeshare companies do their deeds internally. So you'd want to reach out to the timeshare company directly and ask them to verify how title is held. And if title to the timeshare isn't in the trust, you're going to want to ask the timeshare company to go ahead and update title to put that house or the timeshare, sorry, into the trust. The only thing that doesn't go into the trust are retirement assets. For those assets, you always want individuals or charities, primary, secondary, and then vehicles. When it comes to your cars, generally speaking, cars don't have to be put into the trust. California does give you a small bucket of money that if you had assets in your individual name that didn't have a beneficiary attached to it, if you added all of those types of assets together, and as long as their total aggregate value is under $166,250, then those assets don't trigger probate. So if I had a bank account in my individual name that didn't have a beneficiary tied to it, and if that had $50,000 in it, and if my car was worth $40,000 and that's in my individual name, and if I passed away, because those two assets added together are under the $166,250, they wouldn't trigger probate. And your trust is revocable while you're living, which means it's changeable. And because it's a changeable, revocable trust, when you put your assets into this trust, you don't have any additional asset protection planning. So sometimes people mistakenly think that when they put an estate plan in place, the assets that they put into the trust, like their home, have greater protection from creditors. But really what the estate plan is doing is it's protecting you if you lose capacity because you're picking the people to manage assets. It's keeping assets out of the conservatorship process. It's keeping assets out of probate, and it's making sure that your intended beneficiaries inherit. That's pretty much what an estate plan is doing from start to finish. So for all of those reasons, when you create an estate plan, you don't have any greater protection over creditors, which is why the cars don't need to go into the trust. If you had creditor protection, I'd say put those cars into the trust all day long, but you don't. So you really don't have to put those cars into the trust, which is why when it comes to these assets, you want to make sure that everything's properly insured. You want to have a good homeowner's insurance on your house and a good umbrella policy on the house. You want to make sure that you have good vehicle insurance on the car. So sadly, if you were involved in an accident, the benefit of having good insurance is you're not having to pay out of pocket should the insurance run short. So I do like to just mention that when you create an estate plan, unfortunately, you don't have any asset protection with these documents. So when you're thinking about putting an estate plan in place, you're going to want to give some thought as to who the people that are in your life that you trust that could be your successor trustees. A successor trustee is the person you entrust to manage assets while you're alive but incapacitated. They also administer the trust at the time of your death, which is the process of paying all your bills, paying your final taxes, and then making distributions to your loved ones. So when it comes to a trustee, you want to pick somebody who's good with money, who's good with their own money management. You wouldn't want to pick somebody that you know is bouncing checks and is kind of, not so diligent when it comes to their own management of their own finances. You also want to pick somebody that you think would be fair to your beneficiaries. I've unfortunately have seen some situations where a trustee favors one beneficiary to another, and legally that is a breach of their fiduciary duty. So you're best off just not picking people to have that role that are going to have those types of, favorites and things. So you want a trustee who is good with money, that will treat the beneficiaries fairly. Sometimes people ask me if the trustee can also be a beneficiary. That answer is yes. There is not an inherent conflict of interest with the trustee also being a beneficiary. But when you are a trustee and a beneficiary, you can't put your beneficiary interest above anybody else's. But it really comes down to who is the best person for that job. I had a client one time who had 12 children and she didn't want to hurt anybody's feelings, and she wanted all 12 of her children acting unanimously. And I had the unfortunate job of having to tell her that that just was never going to work. So I wouldn't do her estate plan because I just wasn't willing to write an estate plan like that because it just wouldn't work. So when it comes to picking a trustee, with all due respect, it's not about hurting people's feelings. It's really about picking the people that would make the best money manager, because that's what you're asking them to do. And then medical is completely different. It's not uncommon that whoever you pick to make financial decisions might be a completely different list than who you're picking to make your medical decisions. And then again, you do want to review and update these documents about every 8 to 10 years. And in my experience, updating trustees is the #1 change people make. And it makes sense because, you know, whoever I might have picked 10 years ago to be a trustee, 10 years later, maybe their health isn't so good. Maybe their capacity isn't as sharp. Maybe they've gone through some bad situations, and maybe their whole stability isn't as stable as it was. I've had some people change trustees because the person they picked has a gambling problem that they've just found out about. So, and people pass away. So changing trustees is one of the most common changes people make to their estate plan. So for that reason, I don't encourage people to share their estate planning documents with their loved ones, but I do ask them to let their loved ones know that they have an estate plan, where they keep the estate plan. It's only the medical directive that I think is an important document to share, because if my husband and I were both hit by a drunk driver, and if we were both side by side in the hospital on medication and not able to make decisions, then thank God we took the time to give the people that we trusted to make medical decisions a copy of that medical directive, because they can pull it from their file, give it to the doctor, and start making those decisions immediately. I also encourage clients to take their medical insurance card, to photocopy it front and back. There's a place on our medical directive where you can handwrite all of your loved one's contact information, cell phone numbers, email, what have you. And you want to attach that medical insurance information and the phone numbers to that medical directive. And you'll want to keep a copy of that document in the glove compartment of your car. I have mine and my husband's medical directive in his glove compartment and in mine, so that anytime we're traveling or driving anywhere, those two medical directives are right there in the glove box, along with medical insurance information and phone numbers, should there be an accident. We also gave a copy of our medical directive to our neighbor, asking him if he happened to see a police car or an ambulance in our driveway, if he would mind just giving them our medical directive. So the medical directive is the one document I do encourage you to share with your family and friends. You can do what we did and give a copy to somebody who's not on there, like a neighbor, but with the idea that they'd be the conduit to get that important document to the emergency personnel. And then what else? With the medical directive, I also encourage people to leave that in a public, not in a public place. When you're traveling, you want to take your medical directive with you. My daughter's on a cheer team, and so we have some out of town competitions. And anytime we get to the hotel room, I'm always leaving the medical directive in plain view. I do that because at one of these competitions, one of the parents actually did have a medical emergency where she fainted in the elevator. She hit her head. She was unconscious, rushed to the hospital, and the hotel was basically trying to figure out who she was, because they didn't know who she was. So sharing the medical directive is definitely an important document to share. And then letting your loved ones know that you have an estate plan and where they could find it is important, but not necessarily giving copies of the financial documents, because chances are you're going to change your trustees over time. And then you, like I said, you do want to revisit these documents about every 8 to 10 years, because the legal language should be updated. One of the great things about UCSD is that ARAG legal insurance program that they offer all of you. So for those of you who have ARAG, estate planning is covered by that legal insurance. And it's kind of a use it or lose it. You get so many hours a year, and if you don't use it, they just go away. So we're honestly the busiest this time of year, because so many of our clients with ARAG call because they want to use their benefits before the end of this year, so that come next year, they've got all those hours next year available. So I do encourage you to use that insurance. It's a great benefit that you have. And that's pretty much everything I wanted to talk about. So that's pretty much estate planning 101, talking about trust, wills, healthcare directives, and durable powers of attorney. So if any of you have questions, my contact information is on that handout. I'd be more than happy to answer any questions if you wanted to email me privately. But that's it. Thank you guys so much for attending the Zoom today. And hopefully you learned some good information.
Thank you so much, Heidi. Does anyone have any quick questions now since we have her online and she's able to answer them? You are free to unmute or post in the chat.
I have a quick question. Hopefully this is easy. So if I have a joint bank account with my husband, but then I need to set up a separate account for other assets that have been inherited, etc. Do I need to have an EIN number for any new accounts, or is my social security number adequate for that?
That's a great question. So the answer is while you're alive, it's your social security number that ties you to your assets. But then once you pass away, your social security number dies with you. So it's only at your death do we replace your social security number with a tax ID number. So if you have inherited assets that are your separate property that you're going to put into your own separate account, the bank will want your social security number on those assets.
Okay, thank you.
You're welcome. Good question. Oh, and there's a question. It says, when was the information sent out? Those handouts were sent out today to everybody in an email.
Yes, if you did not receive it, I can resend right after this meeting, as well as along with the recording for this presentation. And then one quick question, Heidi, I don't know if you reviewed it. There was so much information, which is great. Can you put stipulations on your beneficiary receiving parts of your estate or your assets? So like they have to complete college or do this or do that. Is that something people can do as well?
Yeah, so I have a lot of people. I mean, that's part of what's so great about an estate plan is every estate plan is individualized. We have language in our trust that says if our kids are married at the time of inheritance, we're going to have them inheriting the money in their own separate name to retain the separate property status. We also have a substance abuse clause in our trust so that if our trustee thinks that our beneficiaries are having issues with illegal drugs, they can ask them to submit to a drug test. And if they fail that drug test, then the trustee has some additional discretion to postpone a distribution to that beneficiary, but they can continue to use that beneficiary's monies to pay for their health, education, maintenance, and support, and even rehab if the beneficiary is willing to go. So you can put age contingencies in place. You can have substance abuse provisions in place. There's also a spendthrift clause in our trust, which I think is really important. Basically, what that is if my husband and I, for example, passed away, and let's say one of our kids was going through a really bad divorce, they could ask the trustee to keep their monies in trust until after that divorce is over, so that way their soon-to-be ex-spouse can't try to claim that their inheritance is community property. Just like another example, if one of my beneficiaries was going through a bankruptcy, they could ask that these monies that they're inherited stay in the trust until after the bankruptcy and all the creditor period is over. So there's a lot of things that you can do with the trust that protects beneficiaries that you can't do with a will.
Thank you so much.
Yeah,
I don't
pleasure.
see other questions. Does anyone else have a quick question for Heidi? If not, I'm sure they'll reach out. We'll send the recording and the handout. Thank you so much, Heidi, for being here with us today.
Thank you, guys. Have a great rest of your day.